Hey guys, and welcome to today's video. Buckle up, because we've got a few hearings to cover, and they get progressively more ridiculous as we go. We're starting with a softcore sovereign citizen who is genuinely challenging Eric Martin for the prestigious title of dumbest sovereign citizen on Earth. If you're new here, allow me to introduce you to the man, the myth, the malfunction, Don Maku. Now, Dan is one of those guys who walks into a courtroom with the confidence of a supreme court justice and the legal knowledge of a boiled potato. His grasp of the law is so flimsy that even the other sovereign citizens probably look at him and say, "Dude, seriously." Today's hearing is a perfect blend of ignorance, misplaced confidence, and the kind of accidental comedy you only get from someone who learned everything they know about law from two YouTube videos and a TikTok duet. Dan comes in fully committed to the bit papers in hand, nonsense ready to launch, and absolutely no understanding of what he's about to walk into. So without further delay, grab your snacks, hydrate, and prepare yourself mentally, because Dan is about to demonstrate just how far a person can drift from reality when they think Google Plus vibes equals legal expertise.
Let's call the case of the people versus Daniel Magoo. State your name.
Daniel Magoo.
All right. What are we doing on this today?
Your Honor, I have in regards to case number 25F4-523, I have a couple things I'd like to point out about a couple of the matters here today.
Go ahead.
In regards to count 3, MCL 750197, lawfully detained or imprisoned in jail or confinement. Judging by the definition of the statute itself, Your Honor, it compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, defendant was located in a hospital and not a confinement by government agency or jail. So I'm requesting that that charge is invalid on its face.
That were going to be addressed. That would be addressed at a preliminary examination, sir, as to the sufficiency of the charge. So if you're making a motion that I dismiss it at this point, that motion's denied.
Okay. Further, in count 2 and count 1, actually, Your Honor, both of these were, I don't know the procedural process or when it should get raised, but both of them are Fourth Amendment violations. And furthermore, on count 2, MCL 257.904, that the license of the defendant was revoked or suspended, given the statute as well, Your Honor. That would require the prosecutor to prove that the license was revoked or suspended at the time of the arrest, and that defendant was notified, and that the defendant operated a vehicle on a highway or roadway. I challenge the prosecutor to prove all three.
Sir,
Yes,
you
sir.
wish to have a preliminary examination in this?
I'm making sure we're prepared for it, but yes.
What'd you say?
Making sure we're prepared for it, but yes, I am. What are the other options? I'm requesting that all the charges are dismissed. A motion for all dismissal on all these charges.
You can request all you want, but Judge Simpson has watched you play games with the court long enough to recognize exactly what you're doing. This isn't his first rodeo with a sovereign citizen who thinks that repeating the same 5 buzzwords in slightly different orders somehow creates a legal force field. Dan has been pulling the same nonsense for months, filing meaningless motions, demanding imaginary rights, refusing to answer basic questions, and generally treating the courtroom like it's an improv stage where the only rule is yes and. But also, I don't consent. Judge Simpson has seen every trick in Dan's extremely short playbook, and he's well past the point of being entertained by it. So when Don stands there with his chest puffed out, announcing that his case must be dismissed upon his request, he genuinely believes the judge will stop everything, snap his fingers and say, "Well, why didn't you just ask earlier? Your Royal Highness of Nonsense Land. Case dismissed." But here's the problem. That's not how anything works. Not in Michigan, not in federal court, not in any court on planet Earth or in whatever alternate dimension Don thinks he's operating from. Something tells McCall it's intuition. Call it pattern recognition. Call it the accumulated frustration radiating off Judge Simpson's face that he's not going to suddenly abandon decades of legal procedure just because Dan stomped his foot and declared it so. If anything, Dan's little performance is just adding more fuel to the fire every time he tries to twist the law into whatever shape matches his fantasy worldview. The judge is reminded that this defendant isn't confused. He's intentionally wasting everyone's time, and judges love that. So no, Dan, you're not getting your magical dismissal today. What you are getting is a judge who has run out of patience and is about to explain to you, in very small words, exactly why your request is worth less than the paper you printed it on. Clip 2.
They're not going to be dismissed.
No, okay.
So if you want a preliminary examination and make your arguments, then it might be that they would be dismissed at that point, but they're not going to be dismissed on an oral motion before this.
Okay, Ms. Lumby has let me know that all paper discovery has been sent to Mr. McGowan in jail. There are USB drives with video. A number of agencies were involved in the Michigan State Police case, so they responded to assist. I believe she has obtained all of those videos, and those will be sent interdepartmental to jail staff to serve on Mr. McGowan, and I expect those to be in the interdepartmental mail tomorrow.
Got it. Okay, so we're not ready. He hasn't gotten the video.
He has all paper discovery, but he does not have all video discovery. I expect that'll happen. So I'm not sure.
So, Mr. McGowan, are you going to have an objection to an adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the video evidence. So, given that that's not the case and the officers are not here, I would like a speedy trial. I would like to invoke my right to a speedy trial.
So you want your preliminary examination. Those are coming down to the jail to him?
I expect that you would have them early next week. So if the court follows its normal setting for preliminary examination, I would expect.
I would set it for the 19th, and then
have them in well.
he'd have them well in advance, and I guess I'll do it that way. Prior to setting the preliminary examination as being a critical process, a couple of things that the court wants to do. Mr. Magoo, starting in case ending in 0979. Mr. Magoo, you are before the court on a felony complaint that alleges 5 different counts, fleeing and eluding 4th degree, which is a felony punishable by up to 2 incarceration, $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 90 days. Operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200 nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor, punishable by up to 93 days. $500 fine plus court costs, and your vehicle would be subject to mobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025. I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. There is, however, a third offense notice which transforms this into a felony charge. It's punishable by up to $500 to $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively, and 60 to 180 days community service, any rehabilitative programs the court deems necessary. Court could order you to pay the cost of the prosecution, plus cost of any emergency governmental services, and your vehicle would be subject to mobilization. Count 2 is operating while your driver's license was suspended, denied, and or revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is lawful escape from custody, or escape from lawful custody, excuse me. That's a misdemeanor, punishable by up to 1 year, $1,000 fine plus court costs. Mr. Groove, yeah, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I do. I will. I have requested assistance given that I am incarcerated and I have no way to.
Do you wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be represented by?
I've called the prosecutor.
Mr. McGrew, we go through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. I've advised you as to the penalty, the charges, the maximum penalties. I will now ask you the question, and I'm not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel? If you wish to be represented by counsel, this court will ensure that counsel is appointed to represent you. If that is a yes or no.
I would like legal assistance, yes, Your Honor.
Wow. That might genuinely be the first intelligent decision he has made in his entire adult life. For a man who usually treats basic instructions like they're written in ancient Sumerian, actually complying with a direct order from the judge is a monumental achievement. Maybe he's not quite as catastrophically dense as Eric Martin. But let's be honest, even if he momentarily showed a flicker of self-preservation, his haircut is still loudly testifying against him. It looks like he walked into a barbershop, lost a bet, and the barber took it personally.
That is your request for counsel, is how I'm going to take that. And so these two cases now become public defender cases.
Thank you, Judge. Torture Officer, Assistant Public Defender on behalf of the defendant. I believe Your Honor has already agreed to set it for examination.
I will set, he's asked for examination in the case, and so I will set these for preliminary examination.
Okay.
Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay. It's been over, I think, 390 some days since the warrant was requested, and this triggers due process violations under U.S. versus Levasco, People versus Bassard, People versus Rosengreen, and procedural unfairness, Sixth Amendment violations, and I do request that the prosecutor provide or pass the or provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate. And then the third part of the delay or the prong test is to make sure that there was no undue burden on or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that I do have due process 14th Amendment rights as well as 8th Amendment rights. And a lot of these are facially invalid. A lot of these charges are facially invalid. And I'm just requesting that the court grant a personal reconnaissance on my behalf. And for both of these charges, being that we're looking at really just misdemeanors, $500 misdemeanors. So,
But they're not misdemeanors. And you'd know that. If you spent less time arguing with the court and more time actually understanding the charges against you. This would be your third driving under the influence case. Third, at that point, the law stops treating it like oops, my bad, and starts treating it like exactly what it is, a pattern of reckless behavior. So if you're convicted, that charge isn't staying a cute little misdemeanor. It gets enhanced to a felony, which means real prison time, real consequences, and zero patience for your sovereign citizen fairy tales talk.
I think he's requesting, Your Honor, amend his bond, and he's requesting a release, Your Honor, PR bond.
A response from the people regarding his bond.
The people would ask the bond to continue, and he also at the bench were not failed to appear before the judge's plains. So
Yes.
that warrant would also, with respect to the other comment, I'll wait. There are pleadings filed by the public defender's office. Our office will respond to that. And I guess my one remaining point would be, with the court's appointment Eastern the public defender's office, I will make sure that the digital discovery that I referenced is served on the public defender's office.
Yes.
Thank you, Judge. We will review that with our client once we receive it.
So he's asked for a preliminary examination, and I realize where this may be. My understanding is that he is still being held, regardless of what the bond would, in this case, he's being held without bond in Judge Slay's case.
That's my understanding.
That his bond has been denied. So
That's what I
would
Mr. Choda said.
in any event. But also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges, the fleeing and eluding police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind, the defendant, this court would consider a danger to the public. So the extent that he is asking that I modify his bond conditions in his bond in this case, that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence. And,
I understand the presumption of innocence.
and a lot of these are facially invalid, Your Honor.
Excuse me?
A lot of these charges, especially the lawful custody, escape from lawful custody, it's facially invalid. I was at a hospital, not a jail.
If you were under the custody of the Washtenaw County Sheriff's
I was
Office,
not.
I understand.
I was not.
Or in custody of.
I was dropped off at the hospital, and they later tacked on
And
charges,
you know
just
what?
like the fleeing and
evidence
eluding
will
charge.
Not meet that out, and that if that's true, and the people can't sustain that element, then the charge will be dismissed. But I'm not dismissing it upon your representation today.
All right, so that wraps up that hearing. Don Magku will be enjoying an extended, all expenses paid, stay behind bars, giving him plenty of time to scribble out his next stack of handwritten lawsuits against every breathing human in the courthouse, Judge Simpson included. I'm sure the clerks can't wait. Now, let's move on to our next masterpiece of judicial entertainment. A full-blown Karen who has spent weeks harassing and threatening her neighbor, both on Facebook and in person, yet somehow believes she's the one who deserves the protection order lifted. Because of course she does.
In this matter will be set August 19th, 2025, 12 noon. That is before me on that date for both of these cases. I will apprise the parties also that one of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
Oh yeah, in that regard, Your Honor,
Many of those, do not interrupt me. Including many that I don't even know the connection. Court has, this judge, upon receiving this, two things. I read through the complaint to determine whether or not it would on its face create a conflict with court. I consider it, quite frankly, to be frivolous. The complaint itself, do not see that as a necessity for me to recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen, and that is attempting to manipulate the system. He will be dealt with by me as I deal with any other defendant, and so that is there. It has been turned over to the Office of General Counsel for Washtenaw County. They will deal with, for me, and as well as the others that I see that are listed there, they will deal with that. They have also filed, it appears, and again, this is all part of his, what I will call shenanigans to shape this. He has filed against people of individuals without specific reference in the Washtenaw County Prosecutor's Office. I don't, as I view what I read, would not consider that any jeopardy upon their objectivity in handling this case. So,
I'm aware that such filings were being received by our office maybe yesterday. At this point, we continue to proceed with this case and until I hear otherwise from the elected prosecutor.
can I speak on that note, Your Honor?
I will let you talk, but I'm not going to let you go on in some diatribe. I've got other things to do.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of this jurisdiction. Washtenaw County is a named party, and I do believe that my impartiality and bias will be affected here, as it was in the past before this complaint. And I do request a change of venue on that note for both these matters.
If you wish to raise change of venue, you may file that in writing, but to the extent you are raising no motion for change of venue, denied.
Thank you very much, Judge.
Bond will continue. Thank you.
Yeah, you really shouldn't be throwing eggs at your neighbor's house. And definitely don't do it with your daughter like it's some kind of warped mother-daughter field trip. And especially don't do it when the victim has cameras capturing every second of your bargain bin criminal activity. With the price of eggs these days, you might as well be throwing handcrafted gold-plated spheres at their siding.
Versus Renee Campbell, case number 25-05147PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on Ms. Campbell's request to terminate the personal protective order that I granted in favor of Ms. Gay back on June 14th of 2025. I do have to tell you, both ladies, and apologize in advance. I have gotten us behind just through my fault and my failure to move these cases as fast as I'm supposed to move them this afternoon. So I'm a little bit short on time. I don't have time to take extensive testimony on it. I think what I'd like to do is let me see here. Okay, so we're just going to have to keep it quite short. And I guess the way I'll do it is I'll swear in Miss Gay, take her testimony as to the basis for the PPO. I will hear in a response from Miss Campbell why I should terminate the PPO, and then I can make a ruling. So, Miss Gay, if you would please raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I do.
Very good. And to support this protective order, you stated that there were a couple of incidents here, one of them being Miss Campbell throwing eggs at your house. Tell me what happened on that occasion.
After the incident happened, after the altercation with, her and everybody else on the Hall Street,
Yes.
they threw eggs at my home.
Was
and
it
then
during that same big brouhaha on the blow up, or was it later that day or in the evening? When did it happen?
later.
Okay.
And
All right.
then
And who are the egg throwers that you saw?
Renee and her daughter.
And you saw them actually throw eggs at your house?
Yes, because the next day she was on the neighbor's porch, just keep yelling. I didn't throw eggs. I have cameras all around my home, all around it. And I have my cameras, if you come anywhere towards my perimeter of my property, it captures you. It was her and her daughter. They were throwing eggs. And then the next day she was on the neighbors on their porch, just constantly yelling at my house. I've never had a conversation with her yelling. I haven't thrown eggs.
As the judge already explained, the protection order was issued in June, which means anything that happened before that date isn't just unhelpful. It's completely irrelevant to the legal question in front of the court. But of course, like every self-appointed victim of the neighborhood, she's determined to relitigate the entire history of human conflict going back to the Bronze Age if she thinks it'll make her look better. Dragging up months-old drama doesn't change the fact that the PO was based on recent behavior backed by evidence and signed by a judge who's clearly losing patience by the second. Yet here she is, acting like telling the court about what someone allegedly said in February will magically undo a legally established order from June. It's the legal equivalent of showing up to a speeding ticket hearing with a scrapbook of every time you didn't speed.
Today, she was yelling and screaming how she should have killed me. She would have shot me. I had friends calling me because she kept on going online and live streaming how she should have hurt me if I didn't have cameras at my house. And I did submit those. And I was also on the phone with the police on one of the incidents when she was yelling and screaming how she was going to kill me. And I also have a video of her personally, as well as someone sent me one when they was calling me out of concern because of her threats to harm me.
Okay. And my next question, you said you submitted the films. You submitted them to the police department?
Yes, I did. The lives that people were sending me, as soon as they sent them to me, with her ranting and raving about how she was going to kill me, I went right downtown to the police department and I sent it to them. That's two of her telling me she's going to threaten me. I got one actually with her video, and I have her ranting in the backyard, just yelling and screaming and scaring my grandkids, telling them that how she's going to hurt me. And it just went on and on. And I have witnesses guess over like, oh my God, you have to listen to that? I'm like, yes. She keeps threatening me.
Let me see what Ms. Campbell has to say about it. Ms. Campbell, would you please raise your right hand? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, I do.
Very good. Ms. Campbell, you
Well-
say in your response here, you think there should be a termination. It does say you're off probation. What were you on probation for?
I was on probation for the incident with her daughter and stuff, and ever since I've been off probation, she's been harassing me and my I have an 18-year-old daughter, and so she has a daughter that's my age or whatever, and stuff. So basically, ever since that incident, she's now that her daughter, so she basically got her daughter, her grandkids, and like her nieces and them making up stuff. I never once threw eggs at her house. I never said nothing to her. She came to my house, her and her daughter and her grandkids. I
Hang on,
never
you gotta let her testify, Miss Gay, and then I'll give you a chance to respond.
now since she came to my house, that was May 31st. I have two incidents from this year. May 31st, which I put in the police reports, and February 9th, which was the Super Bowl weekend.